SEC wants court to compel Ripple to produce financial statements. A judge ruled in July that XRP may only be sold to institutional investors in order to qualify as a security, and the commission stated that this finding was relevant to the request. Federal court has received a motion from SEC attorneys seeking to force Ripple to turn over records pertaining to its enforcement case. The SEC asked Judge Sarah Netburn to force Ripple to provide financial statements for 2022 to 2023, as well as post-complaint contracts governing institutional sales, in a filing made on January 11 in the U.S. District Court for the Southern District of New York. The contracts pertaining to institutional sales were cited by the commission as being related to a July 2023 court decision, wherein a judge determined that XRP may only be sold to institutional investors in the capacity of a security. The filing stated that the SEC is requesting limited and targeted discovery to help Judge Torres determine if injunctions and civil penalties should be imposed after finding Ripple liable for violating Section 5 of the Securities Act of 1933. It also asked for an amount for the civil penalties. In 2020, Ripple was sued by the SEC for allegedly raising cash using unregistered securities. The defendants included CEO Brad Garlinghouse and Executive Chair Chris Larson. October 2023 saw the commission's filing of notice to withdraw charges against Garlinghouse and Larson, but to keep pursuing the crypto company. April is when Ripple is supposed to start its trial with the SEC. Notable U.S. exchanges like Binance and Coinbase have been hit with enforcement actions by the commission. Stuart Alderoty, who is the chief legal officer of Ripple, has called the SEC a out-of-control regulator because of the agency's stance on cryptocurrency. In the midst of the ongoing legal dispute between the two Ripple XRP tokens, a well-known legal expert has offered an interpretation of the relative calm. And the ongoing legal dispute between Ripple and the SEC has been rather quiet recently, leading some in the XRP community to voice their concerns about the relative calmness of the situation. Nothing has happened since November 2000, when the schedule order for the remedies phase of the case was issued by the United States District Court for the Southern District of New York. This is especially true in regards to the Securities and Exchange Commission. Since the SEC has done nothing, XRP enthusiasts have taken to various social media platforms to voice their displeasure. However, he was surprised to hear that the SEC had not yet brought a damages-related discovery motion. Despite the antagonistic tone of the lawsuit, he is worried that the Securities and Exchange Commission, will file this motion at least 7 days before the deadline of February 12, 2024. After considering all of the likely outcomes, the attorney came to the conclusion that the Securities and Exchange Commission would get the discovery at once, which would lead to a settlement. He foresaw that the securities regulator would engage Ripple in a protracted dispute throughout the remedies briefing if the situation did not come to pass. If the Securities and Exchange Commission goes on with this strategy, according to the attorney, it stands to lose most of its remedy claims. This forecast is based on the SEC's mounting legal losses throughout this period. In the continuing legal battle, the attorney raised an additional possible inference that could arise from the SEC's silence. He claims that the SEC might dispute the Second Circuit Court's summary judgment decision by quickly moving through the remedies stage. For those who may have forgotten, the SEC attempted to file an interlocutory appeal not long after the court issued the summary judgment decision, and Ripple was somewhat successful in its effort. However, the court denied the application and instead directed the regulator to delay submitting its appeal until all unresolved matters were resolved. Considering that last year the SEC chose not to press charges against Ripple staff, an earlier appeal by the regulator is now possible. This is because the remedies briefing is the sole remaining matter in the action. The purpose of this is to give some context. The deadline for the remedies briefing stage is April 29th, 2024, and a decision is expected to be announced in the early summer. It has been formally determined that the legal battle about whether or not XRP is a security has been resolved, as stated by attorney Bill Morgan. Yesterday, a prominent Australian attorney named Bill Morgan said in a tweet that the conflict regarding the non-security status of XRP has been considered to have reached its conclusion. In response to the most recent motion filed by the SEC in the ongoing Ripple dispute, the attorney who supports XRP made this information public. The argument over whether or not XRP should be considered a security has been resolved. Since December 2020, the competition for post-complaint ODL sales has merely the beginning of its war. Taking into consideration that Ripple raised objections to each and every interrogatory and document that the SEC requested. It appears that this will be a contentious battle. As was previously reported, the Securities and Exchange Commission submitted a new motion yesterday in order to compel Ripple to hand over two important papers and respond to an interrogatory. Both Ripple's audited financial statement for the period of 2022 to 2023 and the company's post-complaint contract that governs its institutional sales of XRP are among the documents that the Securities and Exchange Commission is looking for. As part of the interrogatory, the Securities and Exchange Commission is requesting that the court order Ripple to reveal the proceeds from institutional sales since the petition was submitted. A part of the SEC's most recent filing, in which the agency recounted its attempt to file an interlocutory appeal earlier in the action, was brought to Attorney Morgan's attention, which is an interesting development. In its most recent request, the attorneys for the Securities and Exchange Commission highlighted that they required permission to initiate an interlocutory appeal in order to dispute the decision made by Judge Annalisa Torres that certain Ripple's offer and sales of XRP did not constitute securities. Ripple's programmatic sales and other releases of XRP were not found to be in violation of the law, according to the judge's official ruling. In addition, she came to the conclusion that XRP, according to the SEC's assertions, is not a security in and of itself. The Securities and Exchange Commission did not address the matter in its motion to file an interlocutory appeal, despite the fact that many people believed that the SEC would be unhappy with the decision regarding the legal status of XRP. Rather than that, it simply attempted to contest the summary judgment regarding Ripple's programmatic sales of XRP and other disbursements. If the Securities and Exchange Agency makes the decision to file an appeal following the conclusion of the remedies phase of the Ripple litigation, it is possible that the agency will adhere to its initial intention of contesting solely the finding regarding Ripple's programmatic sales and other distributions of XRP. In the meantime, Attorney Morgan stated that now that the conflict about the non-security status of XRP has been resolved, the parties have launched the struggle for post-complaint ODL-related sales beginning in December of 2020. In light of the fact that Ripple has objected to all of the SEC's requests for documents and interrogatory statements, he hypothesized that members of the XRP community would be experiencing a contentious legal battle during the remedies phase. Ripple has made it clear that it intends to engage in regular share repurchases in order to fulfill its commitment to providing liquidity to investors. In light of the fact that the company has altered its plans with regard to the initial public offering that is widely anticipated, this strategic decision has been introduced. To be more specific, Ripple's chief executive officer, Brad Garlinghouse, has highlighted that there are no immediate plans to go public in the United States of America. His key justification for taking such a cautious approach was the regulatory concerns that he acknowledged. That's all for now.